Okay, let's get started. So we're recording now, and this will go to 2:15, but we should not take that long. It'll be more just what kind of questions you may have or issues like that to go over. So basically what I wanted to do today was we'll go through and see if you have any questions through the facts packet and talk about that, and in case you have questions. But before we do that, and probably the bulk of our time here will be to go over this, the final exam advice. So I want to go through each portion of it. Hopefully you've had a chance to read and think about it a little bit, but I can elaborate on some of the issues, and then if you have other questions or concerns, then you can bring them up. So the first thing to do is just think that, what you want to do, and let me just go through the steps. Number one, you want to read through this one time through. Just kind of go through, read it word for word, but get a sense of what's going on. The first time you go through, I wouldn't really take very many notes. You just may want to take the very, very big picture ideas. And so maybe you take down a couple of notes, but I wouldn't get meticulous into it all. I'd really try to see the big picture. So read through it one time, and at this point when you're reading through, just think, okay, is it a criminal or civil case? Basically, what's it for? Who are the parties? What's the charge? What's some of the key evidence? What are some things that are kind of glaring at you? So don't even consider evidence yet. Just kind of get the basic feel for it. Then the second one, after you get the big picture and you have a good idea and you've been through the whole thing once, that's when you start to go back and say, all right, I'm going to now make this into kind of a trial notebook so I could start using it. And the way I'm going to do that is to start making some major distinctions and think about the case a little bit more deeply and logically. So the first thing to do is to think, all right, in this more meticulous look at here, start to map it out, diagram out who the parties are, that just the big picture, that sort of thing. So that's why I say under the one, where you begin to map it out or diagram it out. Determine who the main players are, the plaintiff, defendant, or the prosecution, who the witnesses are for what side, what the claims or the count would be, and try to figure that basically so you're familiar on a first name basis with all of the players. Kind of like a cast of characters. You know, some people put kind of a baseball card together of each person, just with who they are, their background. You can even do some basic, name and age and their job, and how they are important to the case. So that may be something that you want to do with the players. The next thing, and this is one of the most important things you do in any case, and that is to create a timeline. You want to create a pretty detailed timeline of the key events. This helps you in a couple of ways. Number one, you have to make a determination of what is important enough to deserve a timeline designation. And then secondly, even though you understand the big picture, when you put things on a timeline, you get a better overall picture of what's going on. You start to see certain categorical relationships. Certain things start to jump out at you a little bit that you might not otherwise consider were it not for putting it in a time context of what happened. And you've got to think in episodes. You have to think of the general episode and how it unfolded, what the facts are, and this will eventually start helping you with determining what are good facts for the prosecution and bad facts for the prosecution, good facts for the defendant and bad facts for them. So create that timeline. You really want to create that chronology and have that down just as your working context for the background. Now, I'm not going to ask you any questions about chronology or anything like that. You don't need to memorize it to spit back a timeline, but it's more just so it helps your realistic understanding of the case. Also, in the timeline, don't just think of events, but you may want to map out some of the exhibits and put the exhibits in a chronological order too. So if there's something that came out a little bit later, or a statement, someone's deposition, any of those things. So don't just think of it in terms of what happened, but also try to put the exhibits in chronological order as well. All right, after that, after you've sort of figured out what happened, who the players are, the timing, then really go through and figure out, all right, I need to make a distinction between testimonial evidence and then exhibits, maybe even demonstrative exhibits, but I want to pull out, the documents that I might use, the photographs, the email messages, the letters, the depositions, all of that kind of stuff. Pull that out and start thinking about the exhibits and how they might be used, why one side might want to use it, or how it hurts or how it helps. Now, you don't have to get super detailed about it, but just kind of like how you created a little baseball card for each of the players and their significance, sort of create that same baseball card for the exhibit of why it's important, whose side, why it's likely to be used. And even at that point, I wouldn't write it down just yet, but certain things might start to pop out at you. And if they do, you could put that on the other side of the baseball card. For instance, if you see something like there's a letter, and the letter says, Jim said that Tony said, you might think, hey, I bet there's going to be a hearsay issue with that. Or maybe in one of the things it says, Larry's a nice guy. He wouldn't do this kind of thing. That should start to pop out at you a little bit. Now, you're not going to spot every single issue, and you don't want to try and do that yet. But if there are some basic things about the exhibits that pop out to you a little bit, go ahead and note them. Because eventually, when you start going through it the third, fourth, fifth, sixth time, you start to amass certain things occur to you, and that baseball card of the exhibit starts to get longer and longer, and then you could turn that into possible objections and then responses to those objections. That's why when you're in court and you have an exhibit and you're putting it forward, say you're laying the foundation, and then someone objects, maybe it's not foundational, but they say it has hearsay, they say the witness is incompetent, or whatever it might be, you'll have already thought of that possible objection and your possible response. So now it could change slightly the way someone tries to use it, so you'll have to react that way, but you'll have already thought pretty deeply about that exhibit and some of the objections and the evidentiary problems and that sort of thing. And if you've thought about it before, it's easier to dig deeper the next time through. If you just got this cold, it would be harder to react to. That's why preparing for trial is so important, because you go through it so many times, you just know everything cold, and you're ready, and you have way more objections that you've anticipated that the other side never even makes, but you were at the ready. And the few that they do make, then you're able to knock it out of the park, and that's what being prepared is. So do that after you create the timeline and the baseball cards for the people involved and the exhibits and their significance. Decide, are these good for the plaintiff or bad, or good for the prosecution or bad for the prosecution? What role do they play? Then you have to go through the file a little bit, and I would start to divide it in these subsequent parts here. Maybe put, the first part, you're going to have the pleadings. So we need to know what the count is, anything like that. What are we talking about that? The legal claims, any admissions that are made, denials, affirmative defenses. If we are in a civil case, counterclaims, all that kind of thing. And it'll help you because for legal relevancy type of issues, that might be something that you'll think about, and the pleadings will kind of maybe set forth to you what is going on here as a possible issue. So put the pleadings to one side. Then the depositions or the statements. Now, these depositions are in the form of statements. They're not really question and answer, depositions like you'd normally have. And it's just, I wanted to give you this kind of thing, not to load you up with 200 pages where you'd have 100 pages of deposition testimony with questions and answers and a lot of background stuff. So this is kind of like a summary of the deposition, but you can assume it is a deposition. Now, things that should jump out at you at that, it's like, oh, okay, this is a deposition. So anything they say in here that's inconsistent with what they might say at trial would work as a prior inconsistent statement, not just to impeach them, but as admissible for the truth of the matter asserted, because it would fit 801D1A. All right, so now that's just an example of the kind of things you start to think about where you put this in here, like, hey, what possible issues could come up from the pleadings? And I gave you one, maybe legal relevance to see what the legal issue, maybe factual relevance, because you see factually what's going on, what matters in the case and what might not. So there might be some general relevancy type of issues. With the depositions, you want to get kind of the story and also know what person is saying what for, what kind of purpose, how you might use that deposition. Now, I already told you that I do not expect you to memorize the deposition. I'm not going to ask you some little picayune question where there's a slight, he said he lived at 412 Elm Street, and at trial he says it's 421 Elm Street, and you're supposed to know that that's inconsistent. All right, I'm not going to test you on something. It'll be very glaring what the inconsistency is, because that's what's important. But know it well enough so that you don't have to go back, and I think it'll reduce your stress level if you just know it very well, because all of your mental energy, your RAM, can be focused on legal issues and resolving legal problems. The less time, space, energy, stress that you're trying to figure out now, who is Wyatt and what did he do? And is that his wife or his girlfriend? Were they married at the time? Whatever it might be. If you know it real well, then you could get right to whether it's a marital communication or spousal privilege. And you don't have to think, oh no, but if it's his girlfriend or if it's her husband, something like that, it isn't. So you at least want to have the facts down, because the facts you could prepare for. The legal objections, you don't know those yet, so those are to come. But you should already know that which you can know, that which I'm giving you, and I'm giving you this. So try to know it well. Now the test is not going to be a regurgitation of these facts, not at all. It's the legal application of evidence law to them. But you should at least have this down so that you could spend all your time on the legal issues, spotting them, and considering them. Okay, so you have the pleadings, the depositions. You might want to go through and summarize the depositions. That's what happens a lot in real court anyway. But it's helpful because the story might change, or certain things might start to jump out at you in a different way if you summarize the depositions and you realize, hey, they said this. Or maybe in their deposition, they're saying all kinds of inadmissible things. And so those could possibly be issues. So even though it's in their deposition, they may be referring to all kinds of character issues or a former conviction that's inadmissible, hearsay, whatever. So it gives you a sense of what might be future issues. You sort of have that, and again, you're at the ready. Okay, then there's the expert reports. Look for anything in terms of the expert reports. This is a generic thing, and sometimes I have it for criminals. I forget if in this case there is even any expert report. But if so, look at it. And then, ask yourself, if I don't have an expert report in here, does that mean I'm not going to test about experts at all? Or might it mean that I still might test about it, but maybe in a different way? Maybe one of these witnesses tries to give expert testimony. Or maybe they, on the stand, try to qualify some witness as an expert. So you have to spot how that's ridiculous. My baseball card of this guy, he's no expert in this area. So, think of these kind of things of all the while in the back of your mind. If I were Professor Galves, how might I test in a realistic way on this set of facts, evidentiary issues? Because we're limited to this set of facts, just like you would be in a trial. You're limited to the exhibits you have and the trial. You'll always get a curveball here and there. I'll tell you, maybe a witness dies or they change their stories, something like that, but it'll be a little change. It won't be a huge change. All right, so you get those, summarize the reports, what's important, look for weaknesses, inconsistencies, improper things. Are they relying on inadmissible tests or inadmissible evidence where experts wouldn't rely on that? Are they using the ultimate issue? They're using legal buzzwords when they shouldn't? Be thinking of the issues that we have. And that's why it's still good to have your evidence outline. But as you're going through and you're preparing this, you're constantly looking at your evidence outline, because that's a way to help you spot issues if they don't immediately jump out at you. So you might be going through this, you might be saying all of that, then all of a sudden we get to best evidence. And you haven't even considered that. You think, hey, wait a second, there's a contract in here and it's not the original. So I better figure out what I'm going to do with best evidence. That may not have occurred to you were you just looking at this, but when you go through your attack sheet and your outline and the intro and overview and all of that other stuff, you'd say, hey, there may be this kind of issue, and it helps you think, it helps you anticipate. This is what you do as a real attorney when you're preparing for trial. So this process is to try to get you familiar with that and to reward you if you do it well. And if you don't do it so well, then that'll come out in the exam, and so it will reward you for doing a lawyer-like activity. Okay, the jury instructions. There's some jury instructions here at the very end. You want to look at those, again, for legal relevancy issues, but you also want to look at what is going on, what are they going to instruct the jury on. Are there any possible concerns here that I may take into account? Maybe there's a special law here, if you're supposed to apply, like we know with privileges, you do state law privileges under 501, or competency, that's state law. There may be something in here that you have to do. So just, usually not, but look at the law and make sure you understand what the law is, how the jury is going to be instructed. And again, like I said with the exhibits, go back through the exhibits, figure out which is an exhibit, how it helps or hurts, what's indisputable, what's open to interpretation, and then note your issues and concerns. And note, of course, always, for every single exhibit, you're going to need to have foundation. But you think to yourself, every exhibit has to be relevant, and so you want to go through and see, does the exhibit contain anything that might be an issue? And just think about it. That's why it's good when you have your outline, you're consulting it, and you're going through this constant process of trying to spot issues from the facts. Okay, after you do that and you sort of separate your the factual situation out, and like I said, you may want to reprint these one-sided only, 3-hole punch them, get a big notebook, and then after each exhibit or each page or group, you might have little tabs where you tab all your objections, and then after that will be all your arguments that you would use as to either the objection, if it's hearsay, what my response would be, how a court would likely rule, because then you have, you're ready to put in your analysis because you've thought about this so much. All right, so then the thing you want to do is brainstorm. After you've done all of this, brainstorm, but in an active way. And I think you should get in a study group or have a law firm, or if you don't want to do that, at least get together with another person and start brainstorming and talking about the case. Compare your notes. What kind of things have you anticipated or not. If you go through the exhibits and you say, yeah, well, I think the main problem with this one is it contains hearsay, you'll be shocked that another classmate might say, God, I didn't even think of that. I was thinking about the character. And then the other student will say, character? What do you mean? Well, this. Oh, I thought that was just habit. But no, you could make this argument that it's propensity. Oh, I didn't even think of that. Well, I didn't think of that because I didn't even think of it as propensity. If that comes up, I'm going to use it for a non-propensity purpose and just say it's another crime, wrong, or act to show a Miami cop reason, and then we're not even stuck with character or any of the analysis on that. So that will really help you, because when you talk about it with one another, that assumes a basic knowledge that you have to have. And that requires you to really use and apply your knowledge. So you will learn a lot from explaining these things to your classmates and then listening to their explanations and then correcting one another, maybe even getting into arguments about about it. And as it often turns out, it's not that one person is completely wrong and the other one is completely right, although sometimes that happens. Sometimes if you look at the text of the rule, it's pretty clear this person didn't understand the rule. So, because I've resolved kind of those fights, people will come and say, I think he's completely wrong and I think she's crazy. And we can't figure this out. And then sometimes one is right or wrong, but more often than not, they're both a little wrong and both a little right. And if they thought about it in a different way, they would come to the same conclusion. But that's helpful that they did that, because if they would have studied passively and just kept reading the rules to themselves, they never would have done that. So that's why it's important to do this active brainstorming. And again, it's what lawyers do. They get together and they talk about the case. They talk it out. They hash it out a little bit to see, well, what would you do if the judge said this? Well, I guess I would say this. I mean, you need to do that kind of thing, not just memorizing rules, reading the advisory committee notes, and then being able to spit those back. That's the starting point. That's not the ending point. Okay, now, when you go through that and you have all those technical, then I have on here, go from the hyper-technical to the strategic and tactical. So, in preparing the case, make sure you have a very strong technical understanding of the facts of the case. When you go back through and you're rereading it again, this will be very helpful to you. So again, figure out what happened, refine your timeline, refine your baseball cards a little bit, refine your episode explanation of what's going on. You'll notice you'll get to have a better and better understanding of the facts when you start arguing with one another. And then when you say, well, yeah, but what about this? You have to have a good understanding of the facts of the case to even consider something that they said. They'll say, well, but so-and-so in his statement to the police said this. And you'll say, oh, okay. And so you don't get to that place unless you really understand the facts. Then go back and, it's kind of like understand the facts and understand the law, like big news flash, right? But that's what I'm telling you to do. Very strong technical understanding of the facts, and then a technical understanding of the legal issues in the case. So figure out what the possible evidentiary objections are going to be and what the responses should be. Then number 6, prepare and think like a strategical, tactical lawyer. And so what do I mean by this is really try to anticipate, and this is where you get into that thought process or thought experiment. If I were the professor, what would I ask about? How would I possibly test this? What are some of the issues that could come up, right? So I have here this example. You're like a super talented professional hiking guide that skillfully and competently leads your clients through complicated legal rules. You got to be able to know that stuff to be able to do that. So anticipate issues. You're going to be graded on how well you can spot issues, potential issues. So try to do that now. Try to spot those issues now, because on the exam, you want to be able to really explain and analyze and weigh the strengths and weaknesses of the arguments, get into the nuances, and then provide how a judge would likely rule. So in order to do that, you have to be a few steps prepared, and at least one of them is recognizing issues that would come up. How are the parties likely to respond? Do a lot of play acting and say, well, this exhibit really helps us, but the other side is obviously going to say it's hearsay. So, could I still get it in if I argue that it's not hearsay? Now, here's what happens sometimes. You get so into the admissibility of the issue that you'll say, oh, I'm going to make an argument that we're not using it for the truth of the matter asserted. So then you come up with that argument, you get around the hearsay problem because you say it doesn't fit the definition of hearsay, but then you create another problem for yourself. And that is, well, if I'm not using it for truth of the matter asserted, what am I using it for? And does that even really help me? Does that even hurt my case, maybe? And so it would be stupid to use it for that purpose. So maybe I shouldn't use it at all. And then you might decide, this exhibit, just because I can use it, doesn't mean that I should use it. What would a lawyer do? How would they tactically and strategically, would they even want to get this in here? Now, again, we're an evidence course, not a trial advocacy course. So most of the points are going to be evidentiary admissibility, but I don't want you to ignore strategic, tactical issues. That's why I say, think about those, because that's part of who you are as a lawyer. And then part of that, and this is where you break role a little bit, and that I even give you this advice, but think as a strategic, tactical law student taking this kind of test, and say to yourself, how is he going to test comprehensively on all these issues? If you keep going through and you say to yourself, wow, we spent a third of the class on hearsay and I don't even have any hearsay objections, that's probably not a good sign, right? I've gone through this and I have a whole trial notebook and it's all about relevancy. Every single page is relevancy in 403. Good, I guess, but there's other issues. So think strategically. And then more than anything, try to teach it yourself and say, hey, what would be a good question? And try to stump one another. Try to think to yourself, hey, I'm going to think of an exhibit and then an argument as to why it shouldn't come in. And then I want to see if you can argue to see if it does come in. And when you argue like this and you challenge one another, you push each other to go a little bit further. So, look, if we were a cross-country running team, I would say, let's go run together and let's try to run with one another and we'll push one another because we don't want to be the last one in the pack, and so we'll push. It would still be good if we go and run, if we all go and run on our own, but you're probably not going to run or train as hard on your own as you do in a competitive pack. So try to do that with your law firms. And you could do 2 people and break it up that way, or maybe one time you guys all together might decide to get together as a class or half the class and hash this stuff through. But be thinking about that. How might I try to test evidentiary issues knowing that I'm in the context of the case? So you're going to learn more if you do that. All right, then the last thing is I say take the right test. And what that means is don't take the midterm all over again. The midterm tested things more like a bar exam does, and that is you couldn't use any information. A lot of it is memorization, regurgitation, quickly assessing a factual situation, providing a quick rule analysis conclusion, and moving on, right? And that's okay. That's kind of how bar exams are. And that's your memorization of the rule, the cases, the doctrines, the underlying policy, and then you're kind of regurgitating them back, knowing that I know you know this stuff, right? And you do it as quickly as you can. Well, I already tested that, and we already got that IRAC sort of bar exam experience. That's not what you're doing. As lawyers, you won't do that in an exam. You won't. That's a violation of the code of professional responsibility, Rule 11 to go in there, opining, writing motions for someone you haven't even researched it or thought about it. So instead, take this kind of exam where your analytical, creative, professional, problem-solving skills, all of those things are being tested. And so you're putting that together in a much more realistic case hypo, where the premium is more on preparation and active study than it is on quickly spotting issues, typing fast, and doing some rudimentary analysis and then moving on to the next issue so you get more points. Kind of affectionately known sometimes as a racehorse exam. So the racehorse was more the midterm. This is not going to be so much of a racehorse exam. In fact, one of the 2012 I gave you, part of it was just write a motion in limine saying that Exhibit 1 shouldn't be brought in. And there, it's almost like you're drafting a pleading. Now, I wouldn't require you to do all the niceties of the draft. I would just want the substance. But again, it's not on time and how fast you can write and just kind of throw it up all out there so I could say, yeah, this person knows all this stuff. They've memorized it. They've studied a lot. Now, instead, I want to see is, can you really apply it? And can you do it in a skillful type of way? Remember, it's open book, open note, lawyer, courtroom kind of thing. So the stuff that I'll test you on probably won't be what is the exception to reputation and opinion evidence for character. And you'd say, oh, in 405A, second sentence, you can ask about it, but no extrinsic evidence. Well, you could look that up, right? And so I'm not really testing a lawyering skill if I say, look up Rule 405. What does the second sentence say? Isn't that cool? Like, what, that's the exam? No. So it'll be like, you applying that kind of stuff. So my questions aren't going to be that kind of thing. Now, some of them may seem like that in a sense if somebody says, well, I think this statement contains hearsay, and you can sort of knock it out of the park and it doesn't seem that difficult to do your analysis. So, some of the things aren't that hard. I mean, in the most difficult trials, there are some easy evidentiary issues, and so we're going to have some of those too. Just some clear. I want to see if you know that those are clear, slam dunk, boom, move on. I want to know if there's nuanced ambiguities and there are gaps, conflicts, and ambiguities in the law that you need to use your lawyering ability to fill in. So make sure you take the correct test and make sure you take this more realistic one. Memorizing and outlining, that is a lot of what your tests were like first year and even our midterm exam. Now you're becoming more of a lawyer and applying more lawyerly type skills. And it's not about memorizing and regurgitating. That's not to say that's what you did in the first year, but there was some of that with that racehorse kind of thing. So now it's about skillfully applying the doctrine to clients that we know about. You would know about your client. You would know all this information about them when we go to trial. So that's what we're trying to do. Okay, so that's the exam advice. I think also if you read the law review article, the objection, irrelevant, and unrealistic, that gives you a little bit more as to why to do this so that you can feel good about the exam. I don't want you to feel like, oh, we're doing this crazy exam, and but I have to do it because I got to get the grade. I really want you to at least, maybe you don't agree with that, but you at least understand, hey, this is modeling more what lawyers actually do. I mean, if I went really as far as it possibly could be, then we wouldn't even have an exam at all. You'd go work in law firms, you'd have some kind of evidentiary issue, you'd write it up, I'd talk to the lawyers, they'd give me an evaluation of you. That's probably the most realistic clinical way to do it, but it takes so long, it's so hard, and the perfect issue doesn't come up, and that's why we have simulations. because this simulation really simulates a lot of different areas, and I can ask about the perfect hearsay character, character for truthfulness, relevancy, subsequent remedial measures, all of that kind of stuff. Now, let me give you an example. Well, I don't have I was going to write. I should have brought a magic marker. But I could do this just, if you can imagine where the lines are. But if we say that this piece of whiteboard is the entire subject of evidence, so is my exam, even though it's 3 hours, is it going to cover everything we covered in evidence? There's no way. We had, 45 hours of class, or however much class that we have. There's no way I can test everything. So what happens is you can make it very shallow and broad so that you test every single subject area, but you can't go into it very deeply. And then if you do that, you miss out on a person that has a deep understanding of a very difficult subject, because I'm just getting superficiality. On the other hand, maybe there's a particular issue you're really just going to nail subsequent remedial measures. This should be your law review article on Rule 407. But if you just go narrow and deep, you're missing so much of what evidence was. So, since I can't ask you everything comprehensively that is very wide, and then everything very deeply that may be very narrow but deep, so that you get this whole whiteboard, I'm going to ask you some things that sometimes will seem shallow and broad. But other times I might ask for an issue that has some ambiguities that will require you to go narrow and deep. And here's the problem. You say to yourself, all right, that sounds great. When do you want me to go shallow and wide, and when do you want me to go narrow and deep? And I give you the perfect law professor, law school cop-out answer of it depends, and it's really up to your judgment. But that really is the answer, because it does depend on what the question is, what the issue is, and what it calls for. So by me telling you what it calls for sort of gets rid of one of the very things that I'm trying to test, and that is your judgment. Should this be very involved because it has a lot of moving parts to this analysis, or is this something that is pretty quick, hit it and move on? Like, again, for an example of this, I even used it before, but I'll use it again. Remember item number 5 of the second in the civil case, where he wanted to use the fact that she did not, where Paul wanted to use the fact that Donna did not have automobile insurance? That was a very shallow, wide 411. Yeah, you can't use that. Boom, that was the end of it. You didn't need more than a few sentences to just say it's inadmissible. One thing I was looking there for was sort of the strategic and the tactical, to say, well, yes, but maybe Donna shouldn't object, because if the jury finds out she doesn't have automobile insurance, maybe the damages against her for the property damage will be lower. I mean, this is usually the thing that the defendant or that the plaintiff would not want to bring up, right? So that she doesn't have insurance, because they're going to go easy on her. This is the kind of thing that the defendant would want to bring up. If she had insurance, no. But if she doesn't, she might want to bring up, hey, I don't have insurance. How am I going to pay for this? Feel sorry for me, even though it's clear it's inadmissible, then maybe you got another point for thinking of the strategy that maybe she shouldn't object. Okay, I wouldn't expect a whole diatribe analysis of 411 and the legislative history and talking about how the insurance lobby must have been very powerful to consider Congress to write this rule. It depends what you mean by insurance, and you go into this whole bond thing and blah, blah, blah. You can't do that. To give you an example, I had a student who was an economics major in my civil procedure class, and there was a very slam dunk argument that the amount in controversy in a diversity case has to be over $75,000. And I clearly made it 65 just so they would hit that issue and go on. That wasn't the issue. The issue was the citizenship of the parties, but I still wanted to get a little bit of amount in controversy, and I put another unrelated claim in there for 30,000, but you can't aggregate claims if they're unrelated. So that was the issue. But he went into this whole thing about how $65,000, given the consumer price index and the inflation rate for 3 years, would actually move in, because this had happened a few years back. And if you compound, the consumer price index and you take it into account for inflation, it would actually amount to 76.3997 purchasing power. So it would meet the amount in controversy because of that. And I'm like, hey, nice try, but this isn't really even legal. It's economic and it's kind of squirrely. And there were so many other great Civ Pro issues that you could have talked about, and you fell into this trap of going very, very narrow and deep, and even into an area that's not so much law. So don't do that same kind of thing. Exercise judgment, and that's something you can't really teach. You just have to have it. We can give examples of it, but you really just have to exercise that. Like we've used some sports analogies before, but it's kind of like you can't coach innate speed, right? The person is either super fast or not. Now you can help it a little bit. You can do some certain exercises. You could work on stride length and form and maybe get a little bit faster. But so we could talk about judgment, and I could give you examples, but you really just have to exercise that and show me that when it was time to go narrow and deep, you did. When it was time not to go narrow and deep, you didn't. And you knew the difference. Make sure, too, that you analyze, and when you analyze, you talk about the strengths and weaknesses of the competing arguments. Don't just say, this side would say this side would say that, and then you're done, right? Think of one of the biggest constitutional law cases of all time, Brown v. Board of Education. What if you said, well, the plaintiffs are going to argue that segregating a school system is inherently unequal because it oppresses them based on their race. However, the defendants will say that even if they separate them based on their race, if they give them facilities and books and money that is the same, that separate but equal is okay because it's the equal protection clause. So there's nothing inherently unequal. Okay, then you move on. It's like, whoa, you just spotted the issue and you stated the arguments, but you did no analysis. You just went right to the conclusion. Where's the analysis? Where's the constitutional of which side is stronger and weaker? And then, you might say in that example that the defendants are completely ignoring the psychological effect of the segregation and what that ends up meaning in terms of self-worth, the society's worth, and what these black schools come to represent in a segregated racist society. So you can't just say that as long as the seats have the same cushions in them in one school as the other, now they're equal. All right, so then that gets into a little bit of analysis. You're looking at how strong and weak the arguments are. So you would need to do that sort of thing too. All right, well, that's my talk on the final. That'll be something that I hope that you, as you prepare, maybe a week from now, but a week before the exam or a few days before the exam, you may want to listen to this again to get that thinking. Okay, so do you want to talk about the fact packet at all? Any specific questions? If not, one of the things I would do, just as you're going through this, and maybe I'll pull this out, but I'd read the introduction. Now, the introduction is not part of the case. It's not an exhibit. That's just helpful for you. So put that in there, and that might be part of when you're doing your big picture idea. take it from there. If you're mapping out the general players, you may not have the specific witnesses yet, but the general main players, the defendant, all of that, James, Wyatt, all of that, you'd have that person in here, and you have some basic timeline issues. Then, okay, it's an indictment. I mean, one of the things I would think about right off, this is a criminal case. So, is Galves going to ask anything about evidentiary issues that came up in civil cases? Because if not, then there's a lot of rules that we're not even going to get tested on. However, he often will say this might be the subject of a civil lawsuit. And as it turns out, this would be, because it's hit and run, it's an automobile accident, there's a personal injury, this is a tort. So, that would kind of fit, right? So then be thinking to yourself though, even at that point, there might be something that you'll put later, but as you're thinking, stuff pops out at you. One thing you may pop out at you is, well, in the criminal case, character can be used. In the civil case, there's no character because it's a civil case, unless character is an essential element, like a negligent entrustment of the car. Hey, maybe that's how he'll change the civil case to bring that claim, and then that might be an issue. Or, I remember that in a minority jurisdiction, you can use character, even in a civil case, if the underlying civil action is criminal in nature. All right, so we have that minority jurisdiction, but that's a possible issue. But this might be open for that. So we don't know if that's going to happen or not, but guess what? You've thought about that. You're ready. Now, if you've thought about it, you'll have had time to think it through, maybe come up with an answer. If you haven't thought about it, though, and then you get hit with it on the exam at first, now you're just responding the very first time, trying to think, oh no, what am I going to say? Well, I guess I'll do this, I guess I'll do that. You still have to, the show has to go on. But you'll do much better at trial in real life and on the exam if these kind of things occurred to you. You were thinking actively, you wrote them down, you organized them, and then you're really ready for whatever kind of curveball comes your way. So kind of figure that out, figure out what the counts are, going through the indictment. Stipulations. Haven't even thought about that, but yeah, there may be stipulations. So keep these in mind, because if somebody brings up something, and I might do that just to make sure you're honest. And so I might say, that you didn't show any proof of the injuries or the damages. And then you would say, well, no, that was stipulated to. So, so just know what those stipulations are. And then just try to go through this exhibit and start putting it down and thinking, what does this mean? And I'll tell you, this is one of the most difficult things about being a lawyer, especially a new associate, is when you get exhibits, you've never really seen them before, you don't know what they mean, you think someone else has more expertise than you do, but you just kind of have to slog through the exhibit and see what it means and see whatever evidentiary exhibit there might be there. And so I would just be looking through that area. There's an initial report. Find out who's that from, and who's Paul Burns, and oh, that's a detective, and this is a police report. Oh, something should jump out at you, right? If this contains hearsay, it can't come in. But it's an 8038 public exceptions report, so it can come in. Oh, but if the police officer isn't there, it cannot come in because it's a criminal case. But in the civil case, this can come in, right? So there would be something like that. Now that was an issue too on the midterm that came up. So those were issues, but the same thing here, you think of that. And I know some of that stuff is just stream of consciousness. It flies out of you, you just spot it. But when it comes out of you, put it down. Put it down in an area where you could come back and revisit it. Because once all these things just fly out at you and you put them in an organized area, all of a sudden you have a bunch of objections and a bunch arguments and a bunch of evidentiary analysis on this particular point that you have thought about at different points as you were going through this. Now, you may be good enough where for the first time you see this report and you think, hearsay 402, maybe 407, you can go through and do that, and good lawyers can, but no matter what, you're going to be better if you have had 10 hours to think about it and prepare than if you just do it on the fly. It's good to be good on the fly, but you're going to be, however good you are on the fly, you're going to be better if you had 10 hours to think about it and prepare. So, all right, well, I won't go through each thing like that, but I want you to look at that. And, some things are handwritten notes. Look at some of this, that where people will sign this. Someone says this is key. Who's PB? Paul Brewery or something like that? Who's that guy in here? I don't know him as the cast of players, but when you go through and you look at the lawyers involved or something, maybe that is a lawyer or an investigator or someone like that, and then you can start to decide, who is that Paul Burns? That's a report. Oh, Paul Burns is a detective. Now I know that, right? So you could go through and then decide that that's that person. And then if a detective is making a statement on an exhibit, maybe you could argue that that exhibit should come in with certain handwritten notes redacted. Because although the exhibit could come in, the handwritten note of that person should not come in. But that might be for different evidentiary reasons, even though it's on here, right? And then, there's this diagram of what happened. How is that going to be used? Is that a demonstrative exhibit? Might they try to use it substantively? Who's going to lay the foundation for that? This says Franklin Street. Is somebody asserting that that's Franklin Street? Oh, that must be hearsay. Wait, is it hearsay when you have a map that says Franklin Street? So just be thinking of that kind of stuff. So,
are we to assume that the handwritten notes are statements? Like just, what do you call them? Formal statements by the witnesses? Or?
What do you mean? Oh, you mean these?
Yeah.
Yes.
Yeah. Okay.
Yeah, you could assume that that's what he said as a statement or a letter.
To the police, like he wrote the letter in the police office or wherever.
Yeah.
Okay.
And so when you think about that, and if Wyatt does a deposition, but then Wyatt does something like this, you can only use this to impeach, but not for truth of the matter asserted, where the deposition you could use for truth of the matter asserted if it's prior and consistent statement. This may be more problematic. How are you going to lay the foundation for that? Who's going to recognize this handwriting? What if what I do is I put a police officer to put that in? But that police officer has no familiarity with this handwriting, so how would he know? So that might be an authentication issue. So a lot of this really requires you to think actively of possible evidentiary issues. And you'll be able to do that if you know the law of evidence well, because then you'll start to spot these issues. If you don't, if all you've done is memorized rules, then it's going to be hard to even spot issues. But I think one of the best things to do is talk with one another, and it's not cheating if you talk to one another. That's like saying, if a judge said, hey, are you part of a law firm? Oh, yeah, that's cheating. You got to be a sole practitioner. You can't talk to another attorney in getting prepared to come to my court. Of course you do, so that's perfectly fine. Yeah. Cool. All right, anything else?
I did have a question. Do we have this in like an electronic format that we can print it off easily?
Yes, I put it in.
I didn't see it at first, but I'll look again.
Yeah, it's I think it's in Pages.
Pages, okay.
Yeah, because I have, is it there? Do you see it?
Let's see.
Pages is right above modules.
Oh, it wasn't under, I was looking under files, I think.
I see 2012. Maybe that's what it is.
Yeah, but I think,
I see 2012 facts, 2012 final exam. Score sheet.
oh, and then there's the midterm. I guess I didn't put it under pages. What would I have put it under? Maybe it was in announcements or something. I'll go and I'll put it in again though, because that's one thing with Canvas I've had trouble. Is there?
Oh wait. Oh yeah, that's most recent. Oh wait, what's this? No, that's
No,
the
that's-
Garcia.
No, you know what I did? I think I did that twice,
Oh, you.
and
Okay.
maybe I was thinking that. Yeah, so I'll put this on there.
And if we have questions, we can email you.
Yeah.
As they are, so.
Yeah, I'll put, oh, you know what it is though? I think they are, I think we put this together and they had to scan. Maybe I haven't had it scanned yet, but I'll put it up there. And if you can't find it, email me and say, hey, could you please put it up there? So I make sure that you have this so you can print it off. So, cool. Okay? All right. So are you guys gonna come tomorrow or not?
I might come in the afternoon.
Yeah.
Just because it's easier for me because I have class in the afternoon too, so I might come in.
Yeah. There's also, and I'll put this link up there too, but I think they're gonna record it and there's also a link where you can watch it. So if you were at home, but you just didn't wanna come in, if you just wanna stay at home, you could do that too. So I'll put that up. But either way, you'll be able to look at it. I really think it's gonna be more helpful later on.
Yeah.
Because you have a lot to do to put things together and it'll be a nice capstone to.
I think I want to get my overall outline done, and then I think I want to watch the video while I go through my outline.
Yeah, that's a good plan. But really do try to work with one another. Try to talk, like don't just do it on your own. I know some students, could be competitive. It's like, no, I don't want anyone to benefit from my knowledge. So there's that, but
Yeah.
you're benefiting from their knowledge. And I think the most benefit is trying to explain stuff. So anyway, consider what your working style is, because it helps you figure out too, do I want to be a solo practitioner or work in a firm or some of that kind of stuff too. Many good lawyers do not want to